So now very easy parts of LLP we have covered, and that is the reason I've taken it very fast. But now we'll take up the next ones onwards to be very slow, because these are the concepts now you have to understand it very well. Okay. So now after the advantages of LLP, we have liabilities of designated partner. Now, when you talk about liabilities of designated partner, I've already explained it to you. The designated partners will be responsible for all the legal compliances. That means whatever returns have to be filed, whatever documents have to be filed, whatever legal rules and regulation to be complied with by LLP, everything, the responsibility of that will be with whom? Designated partner. And obviously understand, if there has been a non-compliance of anything, then who will be responsible? Designated partner only. And that is the reason, if there are any penalties imposed in case of contravention of the LLP Act, then the persons responsible for these penalties are going to be who? The designated partners only. Okay, that is the understanding. So liability of a designated partner, unless expressly provided otherwise in the Act. So where they're telling LLP will be responsible or other partner will be responsible, unless that is clearly mentioned, it is assumed designated partner only will be responsible. A designated partner shall be responsible for doing all the acts, matters, and the things as are required to be done by the LLP in respect of compliance of the provisions of this Act, including filing any document, return, statement, and the like report pursuant to the provision of this Act. That means whatever actions, whatever duties, whatever matters, okay, whatever they have to do as under the LLP Act, they are supposed to do it. It is DP who is going to do it. Okay, and may be specified in the LLP agreement also. And they are liable to all the penalties imposed on the LLP partnership, that is limited liability partnership, for any contravention of these provisions. So they're telling anything required by the Act, anything required by the rules, anything required by the LLP agreement, whatever is supposed to be done, the compliance of that will be the responsibility of designated partners. And if they do not do it, then for penalties, they will be liable. Clear? So that is the liability of a designated partner. Now, we already discussed designated partners can be appointed, can also be removed. I mean, can also cease to be working in that particular position. So because of that, can there be a change in designated partner? The answer to that is yes. Okay. But if there is a change in designated partner, then obviously the place of designated partner in LLP cannot be empty, because by law, you require designated partners to be there. So if DP is removed, then in that case, you have to fill this vacancy within 30 days. Okay. And obviously, you have to inform whom? ROC then. A LLP may appoint a designated partner within 30 days of the vacancy arising for any reason, and provision of subsection 4 of section 5 of section 7 of subsection 5 of section 7 shall apply in respect of such new designated partner, provided that if no designated partner is appointed, or if at any time there is only one designated partner, each partner shall be deemed to be a designated partner. Meaning is very simple. These all sections referred there are nothing but they're telling prior consent of him has to be obtained, then he will be appointed. Then you have to inform ROC within 30 days of appointment. That all we have discussed already. Apart from that, here what they say is, suppose if DP is not appointed within this 30 days, then in that case, every partner will become what? Designated partner. That is important to be understood. If no designated partner is appointed, or if at any point there is only one designated partner, then in that case, each partner shall be deemed to be what? A designated partner. Clear? All right. Then, punishment for contravention of section 7 and 9. Section 7 is designated partner and section 9 is filling the vacancy of the designated partner. Okay, so look at that. If the LLP contravenes the provision of subsection 1 of section 7, that is meaning the number of designated partners are less than 2, or either of them are not resident in India, then in that case, the LLP and its every partner shall be liable to a penalty of rupees 10,000. And in case of continuing contravention, with a further penalty of 100 per day, subject to maximum of 1 lakh for LLP and 50,000 for every partner of LLP. Okay, these punishments I cannot help you. You have to remember them as it is. So 10,000, and they're telling further penalty 100 per day, maximum 1 lakh for LLP and 50,000 per partner. Then LLP contravenes the provision of section 4 of section 7, failure to file a consent to whom ROC within 30 days. Then LLP and its every designated partner shall be liable to a penalty of 5,000. And in case of continuing contravention, 100 per day, maximum 50,000 for LLP and 25,000 for every designated partner. Why a designated partner? Why? Understand the logic, very simple. Your designated partner is there because it's a legal compliance, which you have failed to do. So informing ROC was a legal compliance. So here it is only designated partner who has to pay the fine. But in the first point, understand designated partner only is not appointed, or you're not fulfilling the criteria for designated partner. where either they are less designated partners or no designated partners. In that case, we have studied just now that if you don't have the required number of designated partners in the LLP, then all partners will become what? Designated partner. And that is the reason in the first point, what they're telling, every partner. But in second point, they're telling what? Every designated partner. You should understand the logic properly. Third, if the LLP contravenes the provision of subsection 5 of section 7 or section 9, okay, the LLP and every partner shall be liable for 100, the penalty is given 100 per day, maximum 1 lakh and 50,000 for every partner. Clear? Okay. Then, now mark the next point, very important, that is incorporation document. Now we are going to study how LLP gets incorporated. First of all, the body where you have to file the incorporation is going to be the ROC. So here you are going to file the incorporation document. But before that, some important things. Minimum 2 people have to come together, 2 persons have to come together for the purpose of LLP. Second, incorporation document has to be submitted. Third, a certificate has to be obtained by the professionals saying that you're complying with all the provisions required as per the LLP Act with respect to incorporation of LLP. Something similar to Companies Act. So 3 things important. 1, minimum 2 partners. Second, incorporation document has to be submitted. And third, a certificate has to be obtained by the practicing professionals that you have complied with the provisions of the Act. Okay, now look at this. For LLP to be incorporated, 2 or more persons associated for carrying on lawful business with a view to profit shall subscribe their name to incorporation document. So they have to have a profit motive and they have to subscribe their name. Same like subscribers to memorandum, company also should be formed only for lawful purpose. Second, now in companies we have memorandum to be filed, but your memorandum is not there. You have which document? Incorporation document. The incorporation document shall be filed in such manner and with such fees as may be prescribed with the registrar of the state in which the registered office of LLP is to be situated. Same thing again, registrar of the state in which the LLP is to be situated. So incorporation document has to be filed. Now, I told you one statement has to be filed, that's a certificate. A statement to be filed that there shall be along with the incorporation document, a statement in a prescribed form made either by advocate, company secretary, chartered accountant, or a cost accountant who is engaged in the formation of LLP, and by anyone who subscribed his name to the incorporation document, that all the requirements of the Act and the rules made thereunder have been complied with in respect of incorporation and the matters precedent and incidental thereto. Very simple points they're telling you. 3 things only you have to remember. 2 or more persons to carry on lawful business. Second, incorporation document has to be submitted. To whom? ROC of the state where LLP is to be incorporated. Third, there has to be a statement given. Statement by whom it has to be? By the professionals given here, advocate, chartered accountant, company secretary, or a cost accountant. Along with people who have signed the incorporation document. How we say subscribers to memorandum. Like that you have subscribers to incorporation document here. They also. What is the certificate given by them? That they have complied with all the provisions of the Act and the rules made thereunder with respect to what? Incorporation. Not all the provisions of the Act, but only with respect to incorporation. You have to give the statement. Now they have given you the meaning of incorporation document. What is incorporation document? Remember memorandum. Be in the form as may be prescribed. State the name of LLP, name clause. State the proposed business, object clause. State the object, state the address, situation clause. But here you don't mention the name of the state, you're going to mention the address of the LLP. Then state the name and address of each of the persons who are going to be the partners of the LLP. State the name and address of all the partners who are going to be designated partners. Contain such other information concerning the proposed LLP as may be prescribed. So you are going to give name, business, address, all the partners' name, all the designated partners' name, and such other matters as are required. Then, if a person makes a statement as discussed above, which he knows to be false or does not believe it to be, shall be punishable. That means the statement is which? That they have complied with all the provisions of the Act. That statement, if somebody has done it knowingly to be false and is a part of it, that is fraud, then in that case, will be punished with an imprisonment for a term which may extend to 2 years and with a fine which shall not be less than 10,000, which may extend to 5 lakhs. So what did we study here? We are doing section 11, incorporation of the LLP. 3 things. Section 11, subsection 1, which is talking about 2 people, incorporation document. Third, they're talking about is what? A statement to be given by the professionals along with the people who have signed the incorporation document. What is that? That you have complied with all the provisions of the LLP Act and the matter is connected there too. Okay. Then after that, they have given you the understanding of the incorporation document. Section 11, subsection 2 talks about incorporation document. Incorporation document is simply like that of memorandum. And if suppose somebody has given a wrong information in any of the statements filed above, and he knows it to be false, then in that case, imprisonment and fine both will be the punishment. Okay, all right. Now, section 12, when you're reading with me, see that you have a pencil in hand and you make a note of what they're giving. Because the way the language has been constructed here, it is very bad. You'll get confused of what they're talking. So now listen to me properly. Incorporation by registration means what? Now you have filed all the documents with ROC. Now ROC is going to register you as an LLP. So give you certificate of incorporation. That is called incorporation by registration. So now look at this. When the requirements imposed by clause B and C of subsection 1 of section 11, B is incorporation document. C is the statement by all the professionals and the subscribers to incorporation. So look at the previous page. Section 11, subsection 1, clause B and C. B is talking about incorporation document and C is talking about the statement. Meaning is, if you have submitted the incorporation document and if you have submitted the statement which was required by the professionals and the subscriber to incorporation document have been complied with, the ROC shall retain the incorporation document. And unless the requirement imposed by clause A, that is 2 people, of that subsection has not been complied with, okay, he shall, within a period of 14 days, register the incorporation document and give a certificate of LLP is incorporated by the name specified therein. Meaning is, within 14 days, they are going to incorporate you as an LLP and have your name entered in the register of LLP. Okay, now, one presumption is taken by law that if you have filed statement that's signed by all the subscriber as well as the professionals, if that statement is signed, it is presumed that clause A you have already fulfilled. That means there are 2 or more persons, they have submitted for lawful purpose. Okay, so that is presumed to have been done. Understood? So if there is a statement given, a certification given by the professionals and the subscribers that they have complied with the provisions of the Act, ROC will presume, okay, A also is fulfilled. Because understand, complying with the provision is what? You require minimum 2 people to start the LLP. So if you are giving a consent that, yeah, we have complied with all the provisions of the Act with respect to incorporation, they're going to presume there are 2 people minimum present. So can they give you certificate of incorporation? Yes. So look at the next one. The registrar may accept the statement delivered under clause C of subsection 1, that is the statement of fulfillment of the Act, as sufficient evidence that the requirement imposed by clause A of 2 or more people, okay, has also been complied with. Okay, so that means if you have given B and C properly to the ROC, will they incorporate you within 14 days? The answer is yes, because A is presumed that you have complied. Okay, then the certificate issued under clause B of subsection 1 shall be signed by registrar and authenticated by his official seal. Here, which section are they referring? This section only, section 12. That is section 12, subsection 1, clause B. So if you can look at subsection 1, clause B, they say ROC will give a certificate that LLP is incorporated. That certificate is nothing but in the same section 12, subsection 1, if you look at B, they're telling within 14 days, he will give a certificate. So the certificate will be signed by whom? Registrar. The certificate shall be a conclusive evidence that LLP is incorporated with the name specified therein. Same like company certificate is a conclusive evidence. This also certificate will become a conclusive evidence. Logic simple? All right. Then, registered office of LLP and change therein. So do you think it is required for LLP to compulsory at all time have a registered office? Obviously, yes. Otherwise, how communications you're going to have with the LLP? So compulsory at any point of time, registered office of LLP has to be there and the same has to be informed to whom? ROC. What they're saying is every LLP shall means compulsory have a registered office to which all communication and notices may be addressed and where they have been received. A document may be served on the LLP or a partner or designated partner thereof by sending it by post under certificate of posting or by registered post or by any manner as may be prescribed at the registered office and any other address specifically declared to be the head of LLP for the purpose in such form and manner as may be prescribed. Which section of companies that we talk about this? When we discussed about service of documents, we talk about this particular thing wherein we say that, if you want to serve any document to a director of the company, or if you want to serve a notice to the company, then it has to go to where? Registered office. Okay. And it can go by speed post, it can go by courier, it can go by hand delivery, anything. Same thing here, they're telling, if you want to serve any document to LLP, or you want to serve it to any partner, Or if you want to serve to any designated partner, you can do it. How? By addressing it to registered office. Or maybe if the LLP is specifically mentioning, send it to that address, then send it there. Okay, and how can you send it? By post, under certificate of posting, or by registered post, or by any other manner, as may be prescribed. So in their rules also, you have multiple things like courier, hand delivery, everything is there. That also can be done. Okay, so any document to be served to a partner, to designated partner or LLP, it can be done to the registered office or such other place as they must have been specifically mentioning. It can be done by post under the certificate of posting or by registered post or any other means if they are given LLP rules. LLP may change the place of a registered office and file a notice of such change with the registrar in such form and manner and subject to such condition as may be prescribed. And any change shall take place upon such filing only. Same like companies, can we change the registered office of company? Yes. In that case, if you inform home, ROC. Same thing here, you can change it, but here nothing they're told about when to do it, which form to file and all, nothing is told. Just do as per given by the LLP rules. As simple as that. But are you allowed to change? The answer is yes. And if you change, you have to inform home, ROC. That's it. And if you inform ROC only, it is considered to be effective change. Otherwise, it is not going to be considered. If LLP contravenes any provision of this section, the LLP and every partner shall be punishable with a fine which shall not be less than 2,000 or it will extend to 25,000. Fine, your call. Okay, then. Effect of registration, very simple. Imagine LLP incorporated, registered by ROC. So it is now a limited liability partnership. So don't you think now it is a body corporate? Yes. So can it sue people? Yes. Can it get sued? Yes. Can it own property? Yes. Can it buy property, sell property, dispose property? Yes. Okay. Is it an artificial person? Yes. Is it separate legal status? Yes. Same thing here. On registration, LLP by its name is capable of suing and being sued, acquiring, owning, holding, developing, or disposing any property, whether movable or immovable property, having a common seat if it decides to have because it's not compulsory, and doing and offering such acts and things as bodies corporate may lawfully do and suffer. So everything what a body corporate can do, you also can do it. Can you enter into contracts? Yes. Can you enter into business transactions? Yes. Can you take loan? Yes. Can you sell business properties? Yes. Can you acquire some business? Yes. All of this is allowed because now you are what? Body corporate. That is the effect of registration. Simple? All right. Now comes to name. You all know about LLP name criteria. Every LLP should end with the words LLP, that is limited liability partnership. Compulsory it is. Okay, either use the abbreviation LLP or you write the full limited liability partnership. Right, compulsory it is. In companies, we study a concept, the name should not be undesirable. Same thing here, the name should not be something which is not acceptable by the central government or it is undesirable. Like having anything like drugs LLP, or maybe you can talk about human trafficking, or maybe something very bad which is not acceptable by the society at large. Those kind of names are undesirable, not acceptable. So LLP name should be something which is not considered to be undesirable. Okay. Every LLP shall have either the words limited liability partnership or an acronym means abbreviation LLP as the last words of its name. No LLP shall be registered by a name which, in the opinion of central government, is either undesirable or identical or too nearly resembles to any other LLP or registered trademark or company or any other person under Trademarks Act 1999. So when you're forming an LLP, understand till the governing body of LLP is who? MCA only. So do you think the name of the LLP which you're forming could be similar to a name of existing company? No. Existing trademark? No. So can you have a Reliance LLP? Because it is matching with some other existing company. You change the spelling, Reliance you make it, Z you make it. They're not allowed. Why? It is matching to something which is already existing, but it's a company, no problem. So you cannot match or be identical to a company also. You cannot be identical to a trademark also. You cannot be identical to another existing LLP also. Not allowed. Clear? All right. Then reservation of name, something very similar to Companies Act. Can you reserve the name? Reservation of name can happen two places. One, you're proposing to form an LLP, so you want to reserve a name. Or you've already incorporated running the business, but now you want to change the name. In both the ways, are you allowed to reserve the name? Possibility is there because sometimes you are in the fear that somebody else might take the name before you register. So you have an option that yes, we have a lot of procedures to be still fulfilled. Okay, so basically what I'll do, I'll inform the ROC that please keep this name reserved for us. ROC will do it unless it is not undesirable and all that. They will accept it and then you'll be allowed for some period that is going to be how many? 3 months time. And within that time, you have to either register or change it. Otherwise, they will lapse your name. Okay, then anybody else can use it. A person may apply in such form and manner and accompanied by such fee as may be prescribed to the registrar for reservation of name set out in the application as the name of the proposed LLP, that is new LLP to be formed, or the name to which the LLP proposes to change its name, that is existing LLP is changing the name. So either it is new or existing is changing. In both the ways, can we have the name reserved? Yes. Upon receipt of an application under subsection 1 and on payment of prescribed fee, the registrar may, if he is satisfied, subject to the rules prescribed by central government in this matter, that the name to be reserved is not the one which may be rejected on grounds of subsection 2 of section 15. What is that? Undesirable or too identical or similar. That is, they are undesirable in the opinion of whom? Central government. Then in that case, will they accept the reservation? No. So if they are accepting it and they believe it is not in contravention of this undesirability and all, then they will reserve it for a period of 3 months from the intimation to the registrar. Okay, for 3 months they will allow. Okay, all right. The remaining will continue with the next.